New module today, we're going to talk about actions binding the corporation. So this is our third and final chapter in our module about organizational choices and sort of the functioning of a corporation. We began with a conversation about how to select an entity choice. What are the major choices? We have partnerships, we have limited liability companies, we have corporations. We also have the LLPs and LLCs, lots of other like flavors and varieties. We went through the choices that we had, as well as the reasons to select one or the other. And then we talked about forming the corporation, and we had a workshop on that. And we generated some documents. Those are up on Blackboard, and there are two different sets of documents for you on Blackboard. The first set of documents pertains to what we did in class when we created, rigor mortis. So hopefully you got a chuckle there in a kind of dark day, so dark humor. And then that will show you hopefully the core elements of what goes into the actions of the incorporator, the certificate of incorporation, the bylaws, and please note those actions that are taken in the bylaws so you understand what are those initial, sorry, I misspoke, the actions in the organizational resolutions. And so please note what those actions are. They're just kind of the bold headings, so you're aware of the sort of things a corporation has to do when it starts. And then we also have the bylaws, which is going to tie into this chapter. The bylaws are very important for understanding authorization because it's one way of granting actual and implied authority to officers. And we're going to spend 3 weeks on this material, and I hope at the end of it you'll have a pretty clear idea of where we're going. So, actions binding the company, actions binding the corporation really have 5 key concepts. And the first is I will present to you my ideas of agency theory. And I think this will be useful to you in terms of how to think about the issues that we're dealing with, because agency theory and agency cost is a huge reason why we have agency law, is to prevent some of those costs and to make businesses more efficient. And so I'll frame this with the theoretical concepts first, and then talk about when a corporation is bound by the actions of its agent. And this is getting to the law then. So this is getting into the law of agency. And this is actually applicable beyond the corporate sphere. There are many concepts of agency that can happen without a corporation. So we'll then take a look at corporate authority in particular. So going from the very general to the more specific, now we have the concept of corporate authority, and even more particular, how corporations grant authority through board action. We'll talk about the meeting rule. We'll talk about the other aspects about how corporations can grant authority. And then we're going to talk finally in this section, not all today, right, over the course of these 3-week period, about legal opinions. And legal opinions are something lawyers write to convey that authority has been properly granted for a specific transaction. So all these topics fit together, and through this process we'll talk about the various types of authority, actual, apparent, and inherent authority, how it's ascertained, how authority is determined, to what degree an outsider needs to investigate whether authority was present. We'll talk about the meeting rule, the notion that the board only can act as a unit, as a combined entity at a meeting. We'll look at some corporate resolutions, which include those organizational resolutions. That's a type of corporate resolution. We'll look at when a board can act without a meeting, and then talk about those opinion letters. So to begin, we'll talk about agency theory. Agency theory is the concepts found not just in law, but also in economics and in politics that explain the challenges when you have one person acting on behalf of another. And there are really 3 separate concepts here. We need to understand the concept of corporate action. A corporation doesn't have arms and legs. It doesn't have eyes and ears. It doesn't really act in the same sense that people do. Corporations need to act through some type of human agency, so we always have agency issues in corporations, and so we need to then understand who are corporate agents and how do they become corporate agents. It's more than just the CEO. Employees in general have some agency powers. The board is a type of agent acting on behalf of the shareholders. And when are those agents authorized to act? The concept of corporate authority deals with when those agents are able to bind the corporation when it has spoken for them. So we'll begin with an introduction to agency theory. In this introduction to agency theory, I'll discuss the principal-agent problem, and this is really an economics concept, but it informs why the law is the way it is. So it's an important foundation to the law, but it also is applicable in political science and in other fields as well, whenever you have one person acting on behalf of another. And that's the grand idea. When one person acts on behalf of another, the person acting might do so in their own self-interest. This is known as the principal-agent problem. When an agent makes a decision on behalf of a principal, that agent has motivations to act in their own selfish interest, not necessarily in the best interests of that principal for whom they act. I'll give you a simple example to start with. And a simple example that does pertain to corporations is an employer-employee relationship. So let's take a security company as an example. And so this security company has a contract to protect and secure the patrons at the West Orange Pavilion Mall. But as we mentioned, a corporation does not have legs and arms, doesn't have eyes and ears, and so it's not able to itself patrol the halls and maintain safety. It needs someone to do that work. It will need to have an employee. So the security company hires Paul Blatt to patrol the mall and keep it safe, our mall cop. The security company wants Officer Blatt to stand guard at the main entrance and greet the patrons. Just stand there, Paul. But Officer Blatt has a lot more fun and feels a lot more important. He feels better about himself when he's riding the Segway around the hallways. I mean, that's just cooler than standing at the front mall entrance is boring. And there could be crimes happening anywhere. So Officer Blatt decides, maybe thinking it's in the best interest of his employer, but maybe because he thinks the Segway is fun, that he will ride his Segway around the mall patrolling, even though he was asked to stand at the front door. And he can get away with this for a little while, because Officer Blatt has more information about what he's doing than the company does. Right? Officer Blatt knows full well whether he's standing guard or whether he is on his Segway, but the security company doesn't necessarily have that information. And so here we get to some basics. Officer Blatt is the agent in this. He was employed by the security company. The security company is the principal. And so ostensibly, Officer Blatt is supposed to be acting on their behalf. And the fact that the company does not know whether Officer Blatt is standing guard or tooling around on a Segway is called information asymmetry, meaning there's information that one party has or can easily access, and the other party either doesn't have, can't access, or it would be expensive to access. Maybe they could get that information by having a security guard to watch Officer Blatt or a monitor. And so this brings up a fundamental problem I call the be watcher problem. And it turns out that one of the greatest sources, one of the greatest scholars on agency theory is Dr. Seuss. Dr. Seuss wrote a book called Did I Ever Tell You How Lucky You Are?, where he really encapsulated agency theory. And I will read you the quote here, the picture in the background. "Oh, the jobs people work at. Out west near Hwatch Hotch, there's a Hwatch Watcher bee watcher. His job is to watch. It is to keep both his eyes on the lazy town bee, because a bee that is watched will work harder, you see. So he watched and he watched, but in spite of his watch, that bee didn't work any harder, not much. So then somebody said, our old bee-watching man just isn't bee-watching as hard as he can. He ought to be watched by another watcher. The thing we need is a bee-watcher. Well, the bee-watcher watched the bee-watcher. He didn't watch that well. So another watcher had to come in as a watcher. And now all the watchers who live in Watch are watching on watching the watcher who's watching that bee. So you're lucky you're not a watcher, you see. So as you can see in this example, it's obviously a bit comical. You might hire someone as your agent to do some work for you, but how do you know they're doing a good job? And then if you monitor them, how do you know they're doing a good job? And all of these add up to a cost. I mean, think that let's say that all of these watchers are charging $40,000 a year, right? Getting a salary for the work that they're doing. And each of them is actually creating a cost, because how do you know they're doing their job? So as you can see in this slide, I've also pasted the faces of some other scholars who didn't necessarily rise to the level of Dr. Seuss, but have made their own great contributions to agency theory, and I will talk about some of them in this lecture. Ronald Coase devised the theory that firms exist because they reduce transaction costs in general, and we'll see how agency cost is one of these transaction costs and explains why firms would exist. Berlin Means observed that corporations dissolve the atom of property, which leads to the principal-agent problems, and so they need to have mechanisms to fix that. Jensen and Meckling explain how firms employ different strategies to reduce these agency costs, to reduce these agency problems, and to align the financial interests of shareholders, executives, and the employees to alleviate principal-agent problems. Modigliani and Miller, they contributed that a firm's capital structure does not have an impact because changing capital structure doesn't solve agency cost problems. And so we'll take a brief look at their theories. But, it all begins with Dr. Seuss, who had this really brilliant and important insight into the theoretical problems that drive modern agency law. By the way, did you know that Dr. Seuss, his real name was Theodore Seuss Geisel, but Dr. Seuss's first book, which was, and to think I saw it on Mulberry Street, was rejected by over 20 publishers? I mean, the great Dr. Seuss. According to myth, he felt defeated, deflated. Geisel was on his way home to burn his manuscript when he ran into a classmate who convinced him to keep up his work, and he eventually got a contract with Vanguard Press. So even if you forget everything about agency law, I hope you remember this story teaches you one important thing, which is never give up. The world does not always understand great genius, and we wouldn't have Dr. Seuss's insights without that effort. So sometimes you must believe in yourself until the world believes in you. Sometimes you're lucky enough to have friends and partners in life who believe in ourselves even when we cannot. So treasure your friends and honor their dreams. And avoid agency costs. Okay, so back to agency theory, after my quick note there, leaving Dr. Seuss behind and going to sort of the more boring theorists, but maybe the more important ones for at least the application of agency theory in corporate work. Ronald Coase, as I mentioned previously, is a groundbreaking theorist in agency law. And he came up with the idea in a paper in 1937, The Nature of the Firm. He observed that when external transaction costs are higher than internal costs, a firm will grow. And when the external costs are lower than internal costs, the company will shrink. In other words, if it's expensive to have an employee and cheap to have a contractor, you'll have a contractor. If it's expensive to have a contractor and cheap to have an employee, you'll hire more employees. And so the size of the firm depends on not just the cost structure of having that firm, but also the cost structure of the outside market. And he theorized then that firms exist because they're cheaper than the outside market. In the outside world, we deal with prices. If you want someone to do work for you, you pay them for their work. Whether you pay them by the hour, you pay them for the job, you have to go out and get a contract with somebody each and every time you would ask them to do some work. If it's an employee at a company, you don't have to pay your assistant every time she makes a photocopy for you. She receives an overall salary, and you hope that she'll work hard and diligently as needed. So there are some advantages and disadvantages with working with the market versus internally with the firm structure. So the market has its own costs, which will, as they grow, as the market costs, will have more firms, more internal structure, because these external costs would be things like discovering the price of work. It actually costs money to do that, right? I mean, let's say you want to buy a car, you have to do some research to know what that car will cost. It's not necessarily known what something should cost. Negotiating transactions is expensive. Maybe some of us will get paid for that someday, right? So, lawyers' fees and things are part of those negotiations. So in order for a firm to exist, the entrepreneur, the manager of the firm, needs to be able to run the firm more cheaply than it would be to go out into the open market. Otherwise, the firm wouldn't exist. And this is the great contribution of Ronald Coase. He sort of explained why we have companies in the first place and what causes them to grow and to shrink. And to put this in sort of economic terms, a firm will grow larger when the costs of organizing are lower and increase more slowly. So to put it another way, firms will grow when costs of organizing are low, but they will grow more slowly when those costs get higher. And many costs have this U-shaped curve. For example, if you have one employee, it may not cost you a lot of time and effort to watch that one employee, to monitor that one employee. But if you have 1,000 employees, you may begin to be unable yourself to monitor all of them. And there may be additional costs. So many firms and many types of structures, we say there's economies of scale, and there are to a point, but many things also have diseconomies of scale. Once you get so large, things become unwieldy. And so there's sort of an ideal size where firms will grow to a point and then stop growing, and that has to do both with the costs that they experience and the costs in the outside market. And one of those major costs is going to be agency cost. There are other costs, of course, right? Firms have lots of costs. They have their input costs, and they have their advertising costs and their marketing costs. So this is just one of many costs. It doesn't fully explain how large a firm gets, but it's an important cost for lawyers because it has to do with agency law. So let's look at what those agency costs are, and I think there are three key concepts. Three key concepts you need to have in your mind to understand agency costs in general. And the first I mentioned already is asymmetric information. Put simply, asymmetric information means that one party has more information than the other party does. And the cost of that other party to get that information is not zero. It's not free. I'll give you a simple example, one that you might have experienced, buying a used car. When you go to buy a used car, how do you know whether that car was treated well or poorly by the previous owner? It's hard to know that, right? The previous owner could have gotten regular oil changes, could have replaced the timing belt, or could have not. It's very hard for you to learn that information. So there is an information asymmetry between the seller and the buyer. The buyer here has more information. The seller has more information than the buyer. The seller is the one who owns the car. They're the one who did the maintenance on the car. They know whether or not they put oil in it every 3,000 miles. They know whether they replaced the timing belt at 15,000 miles. And they also know whether they cheaped out on the whole thing, put some sawdust in the gas tank, and then tried to pawn it off on you. Right? So that's an information asymmetry. That's a cost. So how does that cost get absorbed into the price? Well, if you're not sure if a used car is good or bad, you would pay less for it. It's one reason used cars are cheaper. In fact, they say that you drive your car off the lot and it immediately loses value. You've heard that expression? Of course it does, because instead of it being a new car that you know nothing has happened to, now there is at least some risk that something has happened to it. And you ask a question, why is this person selling this car? You would never choose to spend as much on a used car as a new car. Right? There's risk now. There's cost because you don't know what happened to it. And we see that things have evolved to try to deal with this cost. Like, show me the Carfax. You can get information about a car. I mean, I bought my car certified pre-owned, and I paid more. Certified pre-owned cars means that the dealer certified that the car was okay. Right? In my case, they did, 151-point inspection or something like that. So what did that do? Well, it reduced some of my risk. It reduced some of my costs. It provided me with information. And so I had to spend money for that. Right? I had to spend actual dollars because the cost of a certified pre-owned car is higher than that of a used car, in part because the used car price will be reduced because of that uncertainty. And so this is the basic idea of asymmetric information. The seller has more information than the buyer, and so this will be reflected in the amount the buyer is willing to pay. Asymmetric information also has a role to play in insurance. When a person goes to get health insurance, the insurer, the company, the policy provider, doesn't know if the person is a smoker or a non-smoker. In fact, life insurance is the even better example. It's statistically shown that people who smoke have a shorter life expectancy than people that don't smoke. Sorry for the news for those of you who haven't heard it yet, but okay, so there's this, it's a statistical reality. And so a life insurance company would rather sell the policy to a non-smoker than to a smoker because it has a lower likelihood of paying out that policy over a period of time. So there is an information asymmetry because whether someone smokes or doesn't smoke can be hidden from the insurance company. There's no way for them to actually determine that. They're not following you around and checking up on you and what have you. They don't know your habits. Right? Well, they don't know your drinking habits. They don't know your exercise habits. They're trying to. But all of these things are correlated with health outcomes. A life insurance company would like to know this information because they would price their policies appropriately, but it's not available to them. So there's an information asymmetry favoring, in this case, the person seeking the insurance policy. And so if that person's a healthy eater or a chain smoker, a marathon runner, or a heroin addict, is not known to the insurance provider, but it certainly affects whether they'd really want to grant that policy because there's a different likelihood of whether it pays out. And they're trying to make money. They want to collect more premiums than they pay out. That's business. So there's asymmetric information favoring the person seeking the insurance. Now, the insurance company might try to address this by providing certain discounts if a person voluntarily reveals information. For example, the health plan we have here provides, I think it's $250 on a quarterly basis if I go and I have my blood sugar checked. And if you self-report on certain diet and exercise regimes. And car insurance is doing this too now, where you can plug a USB dongle into your car and it will monitor your driving habits and give you a lower or higher rate based on whether you're evaluated as a safe driver. So there are mechanisms. They're not free, right? $250 per person for a test, or the dongle, right? Or the risk of alienating a particular consumer. It's not free to make the information more symmetric. There's a cost involved here. But in general, a person seeking insurance has more information about their health than the insurance company does. And asymmetric information, of course, pertains to employees and business organizations as well. The agents, the employees, are on the front lines. They're dealing with the customers. They're working in the stock room, while the principals only get periodic reports. And by the way, the stockholders may not read these reports for a reason called rational apathy, which we can discuss later. In general, the agents of a corporation have more information about their actions than the corporation itself does. And they have more information about their own incentives and their own behavior. A person knows whether or not they're lazy or hardworking better than the employer does. And the employer would like to know this because they'd like to hire the hardworking person and not the lazy person. But it's hard to know this. They might expend effort to do this. They might do various background checks or extensive testing. There's an article about the 51 hardest questions that you get asked in an Apple interview. I guess they're trying to assess something there. But it's very, very hard to get this information. And it creates room for mischief. And the next concept then, the first type of mischief that can occur because of information asymmetry is called a moral hazard. Now this is economic speak, and so don't get too focused on the words. We just have to learn the buzzword. But I can simplify the concept. A moral hazard is when people act inappropriately because of their asymmetric information. Economist Paul Krugman described moral hazard as any situation in which one person makes a decision about how much risk to take while somebody else bears the cost if things go badly. Moral hazard is any situation in which one person, the agent, makes a decision about how much risk to take while someone else, the principal, bears the cost if things go badly. In economic terms, moral hazard particularly relates to when the behavior of one party will change after a transaction has taken place. And so it's after the fact. For example, a person gets car insurance and it covers theft of their car. Might their behavior change? Well, if you didn't have any insurance, would you think carefully about where you parked if If you have insurance, well, what's insurance give you? What's it advertise? Peace of mind, right? Advertise supposed to give you peace of mind. So you park on the dark corner and you walk away with peace of mind knowing that if that car is broken into and stolen, you have insurance to cover it. If you didn't have insurance, maybe you wouldn't park there. So this is an example of moral hazard. After you've purchased the insurance, now your behavior will change because you have it. You have more information than the insurance company does about whether you park somewhere safe or somewhere dangerous. And so now that you don't bear the consequence, or at least don't fully bear the consequence of your car being stolen, you might be more likely to park it in an unsafe place. Now, of course, you bear some cost. There might be deductible, what have you. The idea is simply that some of those costs are pushed off on somebody else. And so the theory goes that people who have insurance are more likely to behave in a risky manner than people that don't have it. And in an extreme case when someone purchases so much insurance on their car that it's worth more if it's stolen, right? I mean, let's say someone has a car that they know is only worth $10,000. For some reason, it's insured at $20,000. Now they actually have an incentive for it to be stolen. So moral hazard can really result in some mischief. And that's the first agency problem, where the person who has the asymmetric information will make a choice after the transaction is made, after, in this case, the insurance is purchased, because they don't bear the full cost of that anymore. And moral hazard also occurs in business associations. For example, imagine a CEO gets a 10-year contract, or imagine your professor gets tenure. It's harder to remove a person under these circumstances, and further assume that it's hard to correlate the efforts of the CEO with the success of the firm, or the efforts of the professor with the success of the class. So, in this case, the incentives are that CEO, that naughty professor, has an incentive to shirk, has an incentive to take it easy. I mean, if that person, knowing that they won't be fired, knowing that they won't be found out, has a choice of working late or attending their son's Little League game, what's better for the company? Working late. What's better for the individual? Attending the Little League game. Now that they have the 10-year contract, now that they have the tenure, is there some risk that when faced with the choice, do I act on behalf of the company or do I act on behalf of myself? I don't take the risk of the bad action. It won't be known. Right? I'm the CEO, and I don't attend the meeting, and the deal doesn't get done, and the company doesn't make X profit on if the deal had happened. It's very hard to ascribe that blame to me, and I have a 10-year contract. I've externalized the risk of that activity, and as a result, have this moral hazard problem. So again, moral hazard is where information asymmetry gives one party the incentive to take advantage of the other party after the contract is made. And that leads us to our third problem called adverse selection. And adverse selection is similar to moral hazard, but it refers to using asymmetric information to take advantage before the transaction is made. It's really just another side of the same coin. And now we go back to our asymmetric information example about life insurance and smokers. This is the common trope that you'll find in the economics literature. Smokers and insurance companies both know that typically, everything else equal, non-smokers live longer than smokers. And so a smoker, knowing this, and knowing that they would pay the same amount as a non-smoker, has a good reason in advance to purchase more life insurance. There's a higher likelihood that that life insurance will pay out over a period of time, all else being equal. Right? Anyone who has any infirmity or any reason that they know they are at a higher risk of mortality and morbidity is more likely to purchase more insurance. Right? But this creates a particularly interesting and complicated problem. Think this one through. So the insurance company knows that it doesn't want to sell life insurance policies to smokers because on average their payments out to them exceed the premiums. They lose money on these people. And there's no way of telling in advance. So we have an information asymmetry favoring the buyers, disfavoring the sellers. And let's think about what effect this will have on prices. Just like if you don't know if a car is good or bad, you will pay less for it than a car you know is good. If you don't know if an insurance buyer is good or bad, right? But in this binary world, we have our proverbial, 6-pack-a-day smokers, and you don't want to sell the life insurance to them. And we have our marathon runner health nut who's got a, into juicing, and we want to sell the insurance policy to them because they're going to pay till they're 95 and never receive, the payment until then, and the other likely to be paid out sooner. So since we're not sure what kind of person we're dealing with, just like you would pay less for a car that you're uncertain about, the insurance company will ask for more. Right? They would need enough money to balance between the people that are likely to pay out and the people that are not. They can't tell who's who. So now they charge everyone a little bit more for insurance because of this information asymmetry problem, because of this adverse selection. So now insurance is more expensive because the insurer knows they're going to have to pay out more premiums. Now for the healthy person, now for the marathon runner, right? For the person who would rather go to the juice bar than the bar, right? The person who's expecting to live a long time. Now they have even less incentive to buy life insurance. Because now they're thinking, oh, life insurance is even more expensive than it was last week. And I know that I'm unlikely to get a payment from that because I'm a very healthy person. And so I'm even less likely. And so what starts to happen is that, you think about that, who is in the pool of insurance. You talk about insurance pool. As insurance gets more expensive, people who know they're healthy will exit the pool. It's not worth it to them. And so now what does the insurance company have to deal with? Well, now they know that as the rates have gone up, the people that are in this insurance pool are less likely to be healthy, so they have to raise the rates, or that they will end up paying out more than they take in. Bad business. What happens when they raise the rates? Even more marginally healthy people. Now it's not the juice bar marathon guy. Now it's the guy who, only has 3 glasses of wine a night and, smokes on occasion. Now they're out of the pool. And now the rates go up, right? Now the problem with this adverse selection is over time, the entire market, without some intervention, will collapse. Because eventually no healthy people will want to purchase insurance. Only unhealthy people will want life insurance. And at this point, now we know who's who. Everyone who's showing up to buy insurance is a bad person to sell insurance to, and the insurance company shuts down. And this is an agency cost story. This is an information asymmetry story, really. This is really getting fundamental about how information asymmetry can lead to adverse selection and can lead to the collapse of entire markets unless there's some intervention. And adverse selection, of course, can apply in business associations as well. Before an employee takes a job, that employee knows whether they're hardworking or whether they're lazy. But it can be hard for a firm to know that information. Firms might try to determine that based on, work history, educational record, a trial period. These are all imperfect solutions. They don't always get to the truth. They all have a cost. And the information asymmetry persists. And so we need to have solutions for this because otherwise we have this persistent problem of information asymmetry which can lead either to moral hazard after the fact or adverse selection before the fact. So how do we reduce some of these costs? There are 4 main ways. The literature talks about 3. I have a 4th to add to the general literature. But there are 4 main ways that firms can engage in activities that will reduce agency costs. But I want to point something out before we even talk about what these are. Anything that a firm does to reduce agency cost actually is a cost itself. It's not free to have that extra bee watcher. Every bee watcher you add represents a cost. You've got to pay the bee watcher salary. And now that everyone's doing it, right, it's hard to get more employees, so you have to pay more. So firms can engage in these activities, but they reflect a cost. So let's talk about what they are. The first, I didn't expect 2 to come up, but that's okay. We'll talk about one and then the other. First is monitoring. Monitoring means what it says. It means looking at your employees and seeing if they're working hard or not working hard. The plaintiff has to watch the agent to make sure that the behavior complies with their interests. We have to make sure that the mall cop is standing at the front door and not tooling around on the Segway. Right? The way you do that is by actually observing them, or, for that matter, paying someone to observe them, the bee watcher problem. You pay someone to do the monitoring, or if you're doing it yourself, if you're the principal and you're an investor, you don't want to be sitting around making sure your CEO goes to work every day. right? You have other things to do, and so all of this represents a cost. You can hire an accounting firm and do an audit. You can employ technological solutions where people clock in and clock out, or you can measure their productivity in other ways. All of these have a cost to them. And let's say you find out that that employee is shirking, that they're a really bad bee watcher. Well, you can discipline them. This was funnier before the election, but I used to have a picture of Donald Trump on The Apprentice saying, "You're fired." So picture that, right? You're fired. That's my discipline, mode here. And what does that do, right? Well, if you're afraid of being fired because you know that you've got the apprentice boss, and you're afraid of being fired, well, maybe you'll work harder in the first place. But firing people has a cost. You discipline your employees and then you fire an employee. Well, sure, that might send a message to other agents not to shirk, and certainly that person can't shirk on the job. But you have to find another agent. You have to go about the job search. I don't know if anyone's worked in recruiting, but it's hard to find good employees. It takes cost, takes money. You have to put an ad out, you have to spend your time, your effort, hiring people. And additionally, as you may know from employment law, the law protects people who are wrongfully terminated. So you fire someone and you run certain risks. You run a risk they'll get upset, you run a risk that they'll sue you, you run a risk that they'll post on Glassdoor, you have a crummy company, you run a risk of litigation. And so there is a cost to disciplining. It's not free. It solves a certain problem and creates another. Bonding is a technical term. And bonding is a slightly different type of cost. Bonding is a cost borne by the agent. Bonding means that the agent needs to prove to the principal that their behavior will comply with the principal's interest. So this is actually an agency cost borne by the agent. So for example, someone who is during a probation period, now if anyone had been on a probation period at work, 90 days, you're working the hours, right? You're there at 9. You're not leaving before 5, right? You're playing the Costanza card and you're leaving your car parked in the lot so that your boss thinks you're there at all hours. So there's some cost to that. It costs something. You're working more hours than you're being paid for to prove to the principal that he should keep you past the probation period. This is called a bonding cost, and it represents a cost to the agent. But it's part of the overall cost structure. And so an agent's not going to take a job if the salary minus bonding costs is negative, so if you are asking for too much bonding from the agent, you'd have to compensate them in some other way as well. So we can reduce agency costs by having the agent prove that they really care about the principal, but it has a cost as well. And so at the end of this story, we have what's called residual loss. And residual loss is simply all the loss incurred by the principal because agent's decisions do not serve its interests perfectly, including the cost, even with monitoring, even with disciplining, even with bonding, there is still some opportunity for the agent to act on their own interest and not the principal's interest. And the principal, or in some cases the agent, had to spend some amount of money to prevent some of these costs. And all of that adds up to a residual loss, the amount of loss that you have because of having an agency relationship. And again, going back to the theory of Ronald Coase, when that residual loss is greater than the cost of contracting at the market, the firm will shrink. You won't have that agent. And when you can get that residual loss down to a manageable level, to a level below that it would cost you to go out into the market, you will hire. And so we can understand the size and story of firms through the story of agency cost. Getting specific with corporations, we can talk about specific costs when you are dealing with the CEO, sort of the most famous one. And so I'll introduce a couple of these concepts here. The first is called empire building. So CEOs generally would rather run a large company than a small company. If you run a billion-dollar company, you get cool things like private jets and a lot of prestige and invitations to, the fanciest country clubs. Now, it's not necessarily good for a company to get bigger. Sometimes it's good for a company to get bigger. Sometimes it's good for a company to get smaller. But a CEO will generally try to make the company bigger no matter what, because it gives them a bigger empire to rule. And CEOs have a certain personality. I won't say what, but CEOs seem to tend to have a certain personality where they may want to have a large empire. And so in the literature we talk about this empire building, because sometimes getting a company bigger does not increase its profitability. Sometimes it just makes things more complicated. The second concept is called capture, which means that a CEO will fail to fire underperforming friends. So the CEO will generally hire from his network, hire people he knows, people he likes, maybe become friends with the people that work at the firm. And those people are doing a crummy job, they're shirking, they're not paying attention. And here's our bee watcher, right? They're watching the lazy bee, but now our bee watcher is friends with the bee. He's captured by the bee, right? He likes the bee's honey. The bee's giving him honey on the side, right? And so as a result, he's less incentivized to actually discipline the employees, and that's called capture. The concept of insulation is similar to empire building, and the idea here is that people like sitting on a huge pile of cash, maybe CEOs more than everyone. And so Apple has been accused of this, right? And so, retaining cash to be independent, especially, because the more cash a company has, for one thing, it's harder to buy that company, because you have to, if you try to buy Apple, you have to buy all their IP and all their other assets and all their cash. Like that's part of that company's assets. The more cash a company is sitting on, it insulates that company from the capital markets, but it can be wasteful. There might be better things to do with that cash, but the CEO, no, he wants to keep his job. So if we keep cash on hand, we can ward off activist shareholders or other issues like that. And finally, the most obvious is executive compensation. I mean, the CEO is going to play some role in saying what his compensation should be. And, I'm pretty sure this is true. I've heard that Congress not only selects their own salary, but whenever they get a chance to vote it up, they do. And no one's surprised, right? And similarly, the CEO knows the boards, friends with all these folks. They're going to try to maximize compensation. And for the most part, actually, they're going to want to minimize their bonuses. They want cash. They want to be insulated from, they don't want the risk. I mean, a CEO, if you had the chance of getting $10 million in cash or $10 million in stock options, most CEOs, without other factors, would prefer the cash, because then it doesn't matter if they do a good job or a bad job, they get $10 million. This is something that annoys people about executive compensation. But in order sometimes to engage in bonding, the CEO will not take all that cash compensation and sometimes take a $1 salary and only get paid in stock options in order to prove that they're really on the side of the principal. So we see that with like Facebook, for example. Question? Oh, okay, shut up. Has it been a while? That's fine. I wonder why. Did it die? Oh. Was it recording at all? Does it have to show pictures? I don't know. It did seem to turn off. It says, yeah. Thanks for letting me know. Although I feel like it's getting a little bit in the way of the class discussion, so I'm going to shut it off in a minute once I get through the more lecture-y portion. Is this going at a good pace? Everyone sort of following those so far? I mean, this isn't really a good time for like the Socratic method, because I don't expect any of you know any of this stuff. I'm just, hoping that the lecture is a good way to at least set the tone. So a CEO then is going to try to maximize their own compensation to themselves, and so they may forego some of that executive compensation for the sake of bonding, but if they don't have to, they probably won't. So there are things we can do to reduce CEO agency costs. You might have heard of some of them. 360 reviews. So getting the administrative assistant to say whether the CEO is really working hard or not is a good idea. Not free, right? And creates its own issues. Incentive-based pay, like giving them stock options or bonuses as opposed to just cash compensation. Making sure the board is independent, not friends with the CEO. But again, that can have a cost because sometimes there are only so many experts in a given field. And shareholder activism. If you make it easy for people to threaten to take over the company and change management, that's discipline, right? It's the threat of discipline. The outside shareholders could come in and fire the CEO. And so as a result, that might cause the CEO to act a little bit more judiciously. With regard to principals and agents, we talk specifically in corporations about a couple different actors. And are you guys, Is this bothering you guys? No. Okay. So I want to start engaging with you guys here. So any questions? Let me actually pause. So I get that was the theoretical stuff, and now we're going to really get into corporate law. Any basic questions? I don't expect you to be experts in this, but I want you to have a working knowledge of the agency theory concepts here. Yes.
So is residual loss just a catch-all for whatever losses aren't covered by monitoring and disciplining and bonding?
Yes. Well, including the cost you incur in doing those things. So if you engage in monitoring, you reduce monitoring cost. If you engage in monitoring, let's say you have this much agency cost, you engage in monitoring and it reduces your agency cost to this much. So that's part of the residual loss, and you spent this much on monitoring. So the combination of what you spent on monitoring and how much cost you have left over after monitoring is part of your residual loss. So it's a catch-all for all that's left over and all that you spent to get to that point. Other questions? So let's talk about corporations. Who acts for a corporation? Do the shareholders? Do shareholders act for a corporation?
Only in voting for who's on the board.
Yeah, only in voting for who's aboard, which is to say basically, no. I mean, they basically don't have the ability to act for the corporation. That's not even really, when shareholders vote for the board, they're not acting for the corporation so much as appointing who will act for the corporation. It's a matter of internal affairs. When I say act for the corporation, I'm thinking outward actions. And shareholders, they're only engaged in these internal affairs. And that includes, they can, by the way, also amend the bylaws, but again, that's a matter of internal affairs. I mean, I'm a shareholder of Apple. Can I go down the street, show people my share certificate and say, Apple is going to engage in a contract with you? No, that's crazy. Of course I can't, right? Because as a shareholder, I don't have any authority. No one should expect that they're going to get a contract with Apple because I have one share of their stock. The corporation is managed by the board of directors. Delaware General Corporation Law Section 141A says the business and affairs of every corporation shall be managed by or under the direction of a board of directors. Shareholders do one thing, and for the bylaws, they delegate power to the board. They appoint the board and they delegate the power of the board as a whole to act on their behalf. The board of directors becomes the situs of corporate power, including having the ability to bind the corporation. So the ultimate power rests in the board. The question then becomes when the board has acted and when the board has authorized others to act. Who are those others? Officers and employees. When we talk about officers, we're talking about the CEO, the CFO, the COO, all those C-suite names. Some people include vice presidents and other ranking, people in that. But also the employees. And all of that power comes from one place, comes from the board. And so if we're tracing corporate authority, if we want to know whether a person who claims to speak for a corporation is doing so, in one way or another, we have to trace that power to a board action that was done properly. Or it has to be in the bylaws. And we'll see both of those examples. So a corporation can become liable to outsiders, right, external affairs, only through its agents, because corporations by themselves, they don't have legs, they don't have arms, they don't have hands, they don't have feet, they can't speak, they can't think. I mean, they're not things, they're theoretical things. And so as a result, they can't bind the corporation. They are the corporation. They can't bind themselves because they can't act. They have to have people act for them. And so they need authority to do that. So this creates a fundamental question. If you're dealing with a corporation, if you're trying to get a contract with a corporation, getting hired by a corporation, expecting a pension from a corporation, selling to a corporation on credit, right? To what extent must you, the outsider, investigate whether or not there's authority? And so we learn about authority because we have two roles to play as lawyers. One role is to make sure that when a board acts, it does so properly and with proper authority. The other way that we as lawyers act in a corporate space in this regard is on the other side of the transaction to confirm that a corporation acted with authority. So we might represent either side of the transaction. While there's a modern trend toward protecting the expectations of outsiders, responsibilities remain for those who are attempting to transact with a corporation to validate that it had authority to be bound. Part of this is, a pretty historic concept. Going back to William Blackstone, who lived from 1723 to 1780, he wrote in his Commentaries of the Laws of England that a corporation is a little republic. And just like our republic, right, Republican democracy, we appoint people to act on our behalf. We just had an election. What did we do that for? Well, we appointed people and gave them the power to create laws that will bind us. Every 4 years we elect an executive who can engage in deals, right? I mean, President Trump talks about this all the time, about how he's great at doing deals. And so we appointed him, right? Or he's appointed. And so he's the president. And so he has the authority to bind the United States in certain international deals. And likewise, the directors of a company, acting as a whole, they have the authority to bind the company, and they can delegate it, just like the president can delegate some powers to executive agencies. So the SEC has certain powers to act on behalf of us. But that power comes through the president, and it comes to the president from being appointed. Just like a COO of a corporation has some powers to bind it in financial transactions, maybe raising some money, issuing some stock, taking on a loan from a bank. It gets that power from the board, who was appointed by the shareholders. So shareholders have the function of electing and removing directors. And while they can't engage in fundamental transactions, we will also see next semester that we need their approval, their express approval. There are some things that are so important that the shareholders cannot delegate that power to the board. There are some transactions, like the dissolution of a company or the overall sale of that company, that we need shareholder approval for. But for the most part, they can delegate that authority. They also amend the bylaws and can pass what's called precatory proposals, recommendations, suggestions, which are more of a public policy standpoint, not really anything with teeth to it. Then the board of directors, again, as a board, the individual, if I have a card and it says director, Microsoft, and I go to the store and I say, Microsoft would like to purchase your copiers, and the person says, okay, how do I know you're authorized? And I say, well, I'm a director. They would be wrong to engage in that transaction. Directors acting alone have no power. They only have power as a board. And they manage the business and affairs, and they also elect the officers. Now, the officers will have certain power. Once they're appointed by the board, the officers will have certain powers, and you can find those powers in a couple places. One is in the bylaws. In the bylaws that you all have in your packets, there will be a section called Officers. There will be a section called CEO, and it will describe, in plain English, what are the powers of the CEO? What are the powers of the secretary? What ability do they have to bind the company? And also the board at a meeting, or as we'll see in some cases without a meeting, can grant powers to a specific officer or to all the officers to engage in certain transactions. Agency law is core to understanding corporate law because corporations cannot act on their own. They can only act through their agents. And so the common law of agency is going to be very instructive in terms of understanding corporate authority and corporate power. What is agency? What does that mean? What is an agent? Yeah, Mary Beth.
A person or entity that has power to act on behalf of another person.
Yeah, power to act on. That's a great definition. I like to use. We're gonna just turn power into authority, right? So we're just going to use that consistent language, but simply stated, that's just right. An agent is someone who has authority to act on behalf of another. And we call that other the principal. Restatement third of agency, section 101 defines it. Agency is a fiduciary relationship that arises when a person, the principal, manifests assent to another person, the agent, that the agent shall act on the principal's behalf and subject to the principal's control, and the agent manifests assent or otherwise so consents to act. Agency relationships are central to all business. All employees, including their managers, must be agents when they have authority to act for the business, or they're basically running rogue. And as a result, agency defines the boundaries of a business association, defines what a person can and cannot do. Companies have some responsibility for maintaining control over their agents, as we will see in a couple of our cases. If an employee of a firm acting on behalf of the firm makes a contract, that firm, in some cases, can be bound, even if it didn't actually authorize the contract. If an employee doing their job injures someone, that firm may be responsible to pay the damages. Respondeat superior, let the supervisor answer. And so deciding who is an agent, who is acting within the scope of their authority, within the scope of their employment, is going to determine the scope of the business and its liabilities. Its liability is a contract, its liability is a tort. Its criminal liabilities. There are several ways agency relationships can be created. They can be created by actual authorization, implied authorization, and maybe inherent authority. So we're going to go through those next. And I have the handy-dandy, what I call table of authority. So here is a depiction of where authority comes from. Authority, in this case, is going to come from the board. The board is collectively the boss. And so the board, when sitting at a meeting, has the ultimate authority over the corporation, and then they can grant agents of that company power to act on behalf of that company, either actually through express language or through implied language, which regards actual authority relates to a understanding between the principal and the agent. When a principal says to an agent, act on my behalf, do such and such, or when an agent reasonably believes that they are authorized to do something because of an action by the principal. So our first concept of actual authority has to do with the actual and implied understanding of the principal and the agent themselves. It doesn't take into account the third party, the person on the other side of that contract. Apparent authority does. Right? And so for apparent authority, I have this image from The Godfather, and the Godfather is whispering in the consigliere's ear. You don't hear it, but you see that the Godfather apparently has authorized his consigliere to act on his behalf. You have witnessed what appears to be a granting of power from the Godfather to his consigliere. And so now, in your eyes, the third party, now the consigliere comes to you and says, we'd like to buy your house for $1,000, Well, now you would be justified in thinking there was a grant of that power because it's apparent to you that the consigliere was authorized by the Godfather in this case. And so apparent authority has to do with the reasonable perceptions of the third party, the person who's not within the corporation but wants to transact with it. And there's an older concept that the restatement has gotten away from a little bit. The third restatement of agency removes it completely. Not all courts follow it, the concept of inherent authority. And inherent authority is similar to apparent authority. It's the idea that because of someone's position, like the fact that they're a CEO, just by that fact alone, you would believe they're authorized to engage in ordinary transactions. We have to define ordinary. But now you see someone's business card and it says CEO Microsoft, and they come to your copier store and they want to buy a $10,000 copier. It's a pretty ordinary transaction for Microsoft. In fact, it's so ordinary you might be suspicious why the CEO is bothering to do it on their own. But because of the nature, the inherent power of a CEO, without more investigation, CEO of Microsoft comes and says, Microsoft would like to buy a $10,000 copier. You're probably justified in believing that, and that concept is inherent authority. You didn't actually see Microsoft talk. You didn't see the board meet and grant some power. You didn't see the Godfather, but you see the guy walking down the street. You know that he says he has a badge on his shirt that says Godfather's Consigliere. You know, you didn't see the whisper, but you know that a consigliere has certain power for sort of ordinary things. And so that's our third concept. Now, actual authority can be divided into two sub-concepts. Express authority, where it's written down and someone is told, you may do X or you may not do X, or you do X in a certain way. You may buy this parcel of land for $1 million. Implied authority arises out of the relationship more generally, and so if a person is authorized several times to purchase small parcels of land, they are authorized by the board 3 times to purchase a small amount of farmland adjacent to a farm, and then the CEO, who was authorized previously, purchases a 4th small parcel. He may have thought reasonably that he had that implied authority. He didn't get an express grant to purchase the 4th parcel, but it was implied in the fact that he's generally given power to make those sort of decisions for the company. And then our last concept is the concept of ratification, which is when the board grants actual express authority after the fact. And so there may not have been authority at the time that the transaction was entered into, but the board ratifies it, stamps it, approves it, and that ratification relates back as if they had granted authority at the time that transaction was entered into. So let's dive into each of these and talk about them in some detail to make sure you really understand them. The first is actual authority. What is actual authority? Yeah, written in the bylaws is one source of express authority, and it says exactly the CEO is allowed to do X, Y, and Z. Now, if something that specific is written in the bylaws, that's correct. The bylaws tend to be pretty general, though. You know, take a look at the bylaws, and when you look at the bylaws, they actually generally are kind of general grants of authority, general powers. They may not speak to a very particular transaction. So actually the bylaws are more commonly a source of implied authority, but it's important, as you mentioned, writing. Yes?
Could it be in a contract of like an employee if you were authorized to do X, Y, and Z?
Yeah, in a contract for an employee. And now, but let's go up to the board level. How would the board say that the CEO can do something? What was the document that we looked at? Yeah. In our organizational resolutions, if you turn to those, you will see, for example, it says that the officers and directors, the officers are authorized and directed to open a bank account on behalf of the corporation. Now that's pretty express, and so express authority is usually a clear grant. I'll give you the restatement definition. The restatement third of agency, section 201, defines actual authority as when at the time of taking an action that has legal consequences for the principal, the agent reasonably believes, in accordance with the principal's manifestations, that the principal wishes the agent to act. So it's about, actual authority is about a relationship between the principal and the agent. And so we need a couple elements, the element of a principal's manifestation, and then the agent's reasonable belief that came about because of that manifestation. Doesn't really matter about the third party yet. So in determining actual authority, the perspective is on the principal and the agent. We do not consider whether the third party was reasonable in believing that there was authority. We only look at what the principal actually did and what the agent reasonably believed. So breaking it down a little further into express authority, this is the clearest form of authority, and this will be found, for example, in those organizational resolutions, and they're usually for a discrete, explicit task, like create a bank account at Bank of America, create a depository account at XYZ Bank. The board had a meeting, or, as we'll see, sometimes can authorize without a meeting with a unanimous consent. It'll be a clear statement by the principal to the agent, growing out of explicit words or explicit conduct, granting the agent power to bind that principal. So corporate authority, as discussed, will usually come either through the bylaws, which will provide some written but often general powers, or more frequently in specific cases at a meeting with resolutions specifically granting a certain power to a certain officer. We'll talk about the meeting rule in a bit. Implied authority is more subtle. Implied authority is inferred from past action. So we still have the element, same element. So again, with actual authority, we have the element of a manifestation by the principal and a reasonable belief by the agent. In the case of express authority, that manifestation was a clear and unequivocal writing to do a certain particular thing. In the case of implied authority, it's a little more subtle. For example, a grant of authority in the past or circumstances that are similar now to a time when that particular agent was granted a particular authority will often give implied actual authority in a new situation. And I have a set of hypotheticals to walk you through all of this because I think you need to see it. But again, we have the same fundamental concept. It doesn't matter what the third party believed. It matters that the agent reasonably believes that they were authorized. Corporate implied actual authority arises likewise when there has been no express action requested, but it can be inferred from the circumstances previously. So that could be from the bylaws. So the bylaws are a source of implied authority because they're going to have a general grant. The bylaws are not going to say the CEO can purchase a $10,000 copier from Kinko's, right, or from Office Depot. It's not going to say that specifically. If a corporation's big enough, the board's not going to meet and say, CEO, go delegate to your, purchaser, to buy a set of copy machines. Instead, the bylaws are going to have a general grant of authority for the CEO to manage the affairs of the business and to engage in ordinary transactions. And so whether the CEO can purchase the copier has to do with whether it's reasonable for that CEO at that company to believe that those words imply that authority. And so a history of approving or not approving certain actions will limit or enhance the scope of implied authority. And then the other way that this can happen, as I mentioned, it can happen after the fact. So the CEO goes out and buys something extraordinary. The company has $1 million, and the CEO commits them to a $500,000 parcel of land. So kind of extraordinary for a company of that size, not common. But the board is really happy they did it and later meets and says that action was ratified. That is also creating express authority. So here's a hypothetical. Take a minute and read it. And the question here is, does Andrew have authority to enter into this transaction? So what do you think? Does it seem that Andrew has authority to sell this horse for $500? Show of hands that says, yes, he has authority. Show of hands that he doesn't look authorized. So where did the authority come from? The answer is yes, he has authority. What type of authority is this? This is an example of express actual authority. Why? Because Priscilla, the principal, said to Andrew, the agent, expressly, go down to the stable, put up a sign, horses for sale, and sell my horses. This is an express grant of authority to sell the horses. She says sell the horses for $500 a piece. He sells a horse for $500. Literally, this is literally what Priscilla told him to do. This is as close to a perfect grant of express authority as we can get. Now, what if Andrew sells a horse for $400? Is he authorized to do that? Well, he's not expressly authorized. We can rule that out. And we always want to kind of take this sequentially, right? Is there express authority to sell for $400? No. But are there some facts where we could find implied authority? Well, what if in previous times Priscilla had accepted 20% less than the asking price? Maybe Andy sold all of her garden implements at a yard sale last week. And she said, sell everything for $5 each. and he sold a couple things for $4, and she ratified it. She said, "Oh, well, I'm glad you sold it. I can't believe you got rid of that dusty old rake for $4. I was hoping for $5, but I'm happy with $4." So what has happened now? Well, by adding that fact that Priscilla had previously ratified Andy's decision to sell something for 80 cents on the dollar, implies he's authorized to do it again. So how does Priscilla prevent this from happening? Well, she might have to say to Andy, this time, don't go under $500. Right? Now again, implied authority has to do with a reasonable belief. Anytime you're dealing with a reasonable belief, you have to deal with all the facts and circumstances. But there is a possibility here that Andy could sell the horses for less if they had previously, in their engagements, if Priscilla was comfortable with that. Does that make sense? So he definitely can sell the horse for $500. Maybe could sell the horse for $400 if there was good reason for him to believe that Priscilla would approve of that, and so he might have implied authority. He clearly doesn't have express authority to sell it for less than $500, but he could potentially have implied authority based on their past action. All right, those are warm-up one. Let's take a look at another one. We're going to stick with Priscilla and Andy for a minute. Same facts. Priscilla, the horse breeder, says to agent Andy, "Andy, go down to the stable, put up a sign, horses for sale, and sell all my horses for $500 apiece." And now instead of cash, Andy takes a personal check. Does this change anything? Yeah.
I think it's more maybe implied because it didn't say what method of payment was acceptable and her, it didn't express instructions.
Please.
And never mind.
Okay. So I think that's the right answer here. I mean, Andrew probably has implied authority to accept a check. That doesn't seem inherently unreasonable. Although, have you ever gone to a business that wouldn't accept a personal check? Right? I mean, not everyone. Why will some people not accept a personal check? Is a check as good as cash? Yeah.
No, because you're trusting that that person has the money.
Yeah, it could bounce. Checks bounce. Cash doesn't bounce. I mean, it could be like forged, but that's kind of ridiculous, you know? I mean, the chance of it being a forgery would be much more minimal. And maybe if they're $100 bills, you're supposed to take out, you know, you've seen the employees at the grocery store. You hand them a $100 bill for a banana, and they're going to take out the pen and make sure that that's not a, you know, so they do have some duty. In fact, that's part of the fiduciary duty. The employee then acting on behalf of the principal would have some duty to confirm that payment is valid. So does he have authority to accept the checks? Well, I think here we could probably reason he does not have express authority because it wasn't expressly said you can take a check. He probably has implied authority, but if in the past Priscilla was not willing to accept personal checks and Andy knew that, right, then we have a manifestation by the principal, Priscilla. The manifestation was, I don't take personal checks, and that should change the reasonable belief of the agent, Andy, who now no longer thinks it's reasonable for Priscilla to accept a check. So implied authority, again, is a little bit more nebulous, not too nebulous, right? We still can find that situs of authority through action. And the question is really whether Andy was reasonable in believing he could accept a check. All right, third hypothetical, same facts. Priscilla, principal, a horse breeder, says to agent Andy, "Andy, go down to the stable, put up a sign, horses for sale, sell my horses for $500. And now Andy accepts a used car in exchange for a horse for a car. So I see heads shaking over here. So what about here? Do we have express authority? Did she say did she say trade my horse for a car, which is effective way to, no, she did not say that. She said sell my horse for $500. We can understand cash. Maybe we understand $500 check, but did she want a car? Now, is there implied authority? Oh, man. Why don't we keep it? Well, this is good to know, by the way. I don't know why it's doing that, though. Maybe it's overheating. Internal temperature high, allow it to cool. Maybe that's what's going on. And I'm learning how to use this thing. So. Maybe a new battery would help? I don't know. I know this lecture is just too hot to handle.
Too bad that joke wasn't recorded.
I think it actually might have been mic'd over there, you know. All right. Yeah, it's probably what's happening, actually. I bet that's what's going on. I wonder if the battery's going out. So hypothetical C, right? In this case, same principal, same agent, same sell my horse for $500. Now he takes a car in trade. Do we have express authority? So we answered no. Do we have implied authority? I want to hear arguments on both sides, okay? What's the argument that he does have authority? Andy wants to feel authorized, right? What's he going to argue? Yes?
He would argue that it's that $500 of value is $500 of value, and that it was reasonable to accept something worth $500 in lieu of actually $500.
Yeah, he's going to use that reasonable term, right? And he might hopefully point to some other manifestations of Priscilla. Yeah, Alex.
I mean, we were looking for a beater anyway.
How about that? Yeah, he knew Priscilla wanted a car, right? Priscilla had said to Andy the week before, I really wish I had a beater to drive, hay around on the farm, right? Or throw manure in the back, something really cheap that I don't mind junking up. Now that's a manifestation by the principal to the agent, creating a reasonable belief that she would accept a car, right? And that would provide implied authority. But arguments on the other side, Priscilla doesn't want the car. She wants to essentially rescind the transaction. Any arguments for Priscilla? Yes.
A sale is a sale, not a trade, so this is outside the scope of the instructions she gave him.
Yeah, I told you to sell it. You traded it, dummy. That's not what I wanted. Yeah, that would be a good way to say no authority. Yeah. Great. So she wanted $500. She wasn't going to take less, but it turns out now she has to pay title and transfer fees, and you probably pay plates and registration and this, that, the other thing. So it ends up costing her more than $500 to get the darn car, and so that doesn't work out so well. It's not what she asked for. Yes.
Well, money is, and a check even is a financial thing, whereas a car is a tangible thing. Maybe she doesn't want a tangible thing, so
Yeah.
she said money.
Yeah. We could even invent other facts too, like she has a car. She didn't want this car, right? She said, I'm really glad I have the car of my dreams. I don't need any more cars, right? That would expressly cut off implied authority.
What kind of car is $500?
Piece of shit.
Not a very nice one, I assume. Yeah, well, it'll probably have more than 1 horsepower, but. Okay, so point aside from beaters, aside from I could change it to 5,000, right? This might be out of date a little bit, but I'm sure. I used to work on a farm in Israel that had like a diesel 1982 Mazda, and I'm kind of when I picture and I remember like it was in the desert, really really cold in the morning. You'd have to sit there for like 3 minutes, like warming the coils to start it up, and like you'd have to like kick it periodically, and it was like noisy and nothing worked. Not even the roll down windows. That might be $500. Yeah, but I'm not an expert on how to find the world's cheapest functional car. Maybe not even it was a functional car, right? The point being that she didn't seem to want it. She didn't ask for a cheap car. She wanted money for her horse. Who knows what she wanted to do with that, but she didn't ask for that. So let's talk about ratification briefly. What is ratification? I've mentioned this, so anyone kind of yes.
It's an action taken without any authority, but the board will later ratify because they agree with the decision.
Yeah, so it's a later affirmance of a prior act. So the act was taken. We don't even have to say without authority. Maybe it was authorized, maybe it wasn't, but you want to clear up the doubt. In the case of the check, Priscilla accepts the check and cashes it. Now, when Priscilla accepts the check and cashes it, she's ratified the acceptance of that check. Now, it doesn't necessarily mean that selling the horse for a check was not authorized. We had some arguments, and it might have been reasonable for him to accept the check, but when she says, good job, Andy, thank you for doing this, and goes to her bank and deposits it, she has ratified that transaction. She has ratified the acceptance of that check. Ratification is the affirmance of a prior act done by another. And it doesn't mean that the prior act was not authorized, but it means that you're trying to confirm that it was. And importantly, ratification then has this retroactive effect. So the transaction was as if it had an express actual grant of authority at the time. And I don't think I have a slide on this. The other thing to mention is that in addition, you can have ratification sometimes by silence or inaction. So, for example, Priscilla gets the crap car. It's on cinder blocks in her front lawn. She comes home and sees it. Says nothing. Waits 6 months. Tries to turn it on, realizes it doesn't start. Has to pay $600, has it hauled away. And at that point, calls up the person, says, I want my horse back, come take your car back. That transaction wasn't authorized. So she never cashed the check, she never drove the car, but there's a concept here of ratification by estoppel or ratification by silence. Usually it's by an express grant, like saying, oh, thanks, Andy, good job, I really like this $500 car, this will suit my needs perfectly. But it could also be simply by inaction, and we'll see that in one of our cases where a president of a company engaged in a transaction he probably wasn't authorized to do, and the board didn't do anything about it for, I think it was 3 months, and they knew about it. And so you have this concept of ratification both expressly and this concept of ratification by estoppel. All right, let's turn the hypothetical just a little bit. Priscilla doesn't tell Andy to sell the horses. And Andy's never sold horses for Priscilla before. Why does that matter, by the way, that Andy didn't sell horses for her before? If Andy sold horses for her before, how would that change things, Paul?
Long-standing pattern behavior.
Long-standing pattern behavior, which can show what kind of authority? Implied actual authority. Exactly right. Right? And if he had sold horses for her before, he was her general horse-selling agent, but he has never sold horses before, and he wasn't told to do it, so we're basically saying in these facts, no express actual, no implied actual authority. And then he sells Secretariat, which we'll later learn is her prized horse, to a stranger, and she comes home and goes, well, I didn't ask you to do that, but cool, I'm glad I have $500. That's a pretty good price for that old horse. Is there authority? I see a nod. Yes. Why is there authority? Ratified the transaction. So this is an express ratification. This is an example of an express ratification. It has the effect of the transaction being ratified in the first place. It's retroactive. It relates back to the transaction. Okay, and now, same facts. Priscilla has never worked with Andy before, didn't tell him to sell the horses, never sold a horse before. He sells the horse to a stranger. She comes home, and let's say for 3 months, she doesn't do anything about it. And then later decides she misses her horse and wants to rescind the transaction. Do we have authority here? Yes.
That would have been ratified by estoppel in that case.
Yeah, so this is somewhere between ratification by estoppel and an implied ratification. So one of those two doctrines would cover this. Either we're going to say that her coming home, seeing it, she didn't expressly say anything, but she seemed to be okay with it, and so maybe that implied that she was, or we're going to at least say she is estopped, she's prevented from raising lack of authority as a means to rescind the transaction because she was silent and didn't respond. Yes? Just forget it, right? All right, let's take a look at some other concepts in agency law here and go on. Well, yeah, you know what? I shouldn't. Then I'm going to come back. Why did I lose that one part of it? All right. Any suggestions are welcome. As I mentioned, I don't know what I'm doing.
I think the stuff that had ever needed to be done, you were in the middle of talking about stuff that was.
People expect to.
Is it not? I mean, this was like supposed to. I wonder if this actually comes out. I think that would help it cool off. Let's give it a try.
No, I'm not gonna be able to tell if it turns out.
Oh, all right. Well, just gonna have to
Trust the system.
trust. Yeah. And at this point, if it does, it does. If not, if not. No, it's good. This is why we're doing a test before, like Bruce is like doing like a real series that actually matters, and so this is why we're doing like an equipment test before I give him advice that might be terrible.
That's what I was gonna say. You wanted something reported last semester, and the light that you go on, and it's like,
Yeah, that's bad when that happens. So it's good to test things in a safe environment before you like go out and do an interview with someone that you like paid $1,000 to fly into town about something really important and realize you didn't capture it. So
hopefully you're not
yeah.
doing all this stuff.
Apparently it won't, yeah, or you have to be careful about it overheating. I'll check online later. Whatever. Point is that we're doing this to see if I could help him with his technology and certainly learn something about how this technology works today. So let's talk about our next concept in agency law, which is apparent authority. And we also say with apparent authority that the agent is cloaked with authority, because the idea is what that person appears to have in the eyes of a reasonable third person. So, the restatement third of agency defines this as the power held by an agent or other actor to affect a principal's legal relations with regard to a third party. Same concept, affecting the principal's relations with a third party when a third party reasonably believes that the actor has authority to act on behalf of the principal. And this is critical, this is what distinguishes this from inherent authority, and the third party's belief is traceable to a manifestation by the principal. Go ahead. Yes. So this is section 2.03 of the Restatement Third of Agency, and I quote, apparent authority is the power held by an agent or other actor to affect a principal's legal relations with third parties when a third party reasonably believes that the actor has authority, that the agent has authority to act on behalf of the principal, and that belief is traceable to the principal's manifestations. And so this is why we talk about this as cloaking. The third party, this is going back to the copier store, right? Going back to the consigliere example, right? You have seen the principal, the godfather, speak to the consigliere. You have seen this person be appointed as someone's representative. And so as a result, you are in a situation where you have seen the principal act. You've seen the principal has named someone to be the CEO of the company. It's a public company, it's verified, it's out there, it clearly happened. And that cloaks that person with certain powers, certain authorities, because you would expect reasonably that that CEO is going to have certain authorization to perform certain transactions. So a principal can create apparent authority by written or spoken words or any other conduct. Any conduct that, when reasonably interpreted, causes a third person to believe the principal has consented to the agent acting for her. With apparent authority, then, the focus is on the reasonable perspective of the third person. And now we actually don't care about the agent. We still care about the principal. In the principal, we look at the manifestations. In both cases, first element, principal's manifestations. The question is, whose reasonable belief about those manifestations matter? In express authority, whether implied or actual, in actual authority, whether implied or express. In dealing with actual authority, we care about the agent's reasonable interpretations of the principal's manifestation. And in the case here of apparent authority, we look at the reasonable belief of the third party in interpreting the principal's manifestation. Corporate apparent authority, then, can be created when an officer's duty and authority allow an outsider to assume that they are permitted to bind the company for the transaction in question. And this is why I said earlier, as I introduced this, that this concept gets a little bit blurred with inherent authority. Inherent authority being, you see someone's a CEO, and you think there's certain things they can do. Like, if CEO of Microsoft, they can probably spend $10,000 on behalf of the company for a copy machine. This is similar, because a corporation can create authority in a similar kind of way, and for that reason I think the third restatement of agency has done away with inherent authority and has rolled it into this concept. But we'll learn about inherent authority because some courts still apply it. So some officers are normally granted no power to bind the company. I mean, think about you can have employees. So you have the janitor, right? The janitor is empowered to do certain things, but if the janitor walks over to the copy store, walks over to Office Depot and says, "Hi, I'm the janitor of Microsoft, and Microsoft would like to buy 3 $10,000 copiers." Now, you are the salesman at Office Depot. When you look at that circumstance, would it be reasonable for you to believe the janitor is authorized to spend $30,000 of the corporation's money? Right? It's not reasonable at that point. And so it depends on the relationships. And so that's why inherent authority and implied authority have gotten a little fuzzy and is maybe not necessary. And the other idea where this comes up, as we'll see in one of our cases, is that if you have mostly this has to do with whether the CEO or the president can do something that they claim to do. And this actually comes down to something a little bit harder as to whether or not the transaction is ordinary or extraordinary. So generally, we know that a CEO is cloaked with the apparent authority to bind the company in ordinary transactions, but the CEO is not generally authorized to bind the company in extraordinary transactions. And so we have to sort of distinguish what is ordinary and what is extraordinary. And if you, the attorney, see an extraordinary transaction, you should be looking for an actual grant of authority. All right, example 8.2a. So, Priscilla says, Andy, sell my horses, but don't sell Secretariat. And then she sends letters to prospective buyers saying, I'm selling my horses and Andy is my agent. Andy sells Secretariat. Now, is Andy expressly authorized to sell Secretariat? No, she said, don't do it. It's clearly not. And does he have the implied actual authority to sell Secretariat? Is it reasonable for Andy? Priscilla says, don't sell Secretariat. Is it reasonable for Andy to think, I should sell Secretariat? Priscilla will like that. No, she said the exact opposite. So there's no actual authority in this case. However, you receive a letter that says, Dear potential horse buyer, I am selling my horses. Come to the stables. Andy is my agent. He is authorized to act for me. Signed, Priscilla. Now you received this letter from Priscilla. Do you now have a reasonable belief that Priscilla has authorized Andy to sell Secretariat or any other horse? So this is apparent authority. He apparently has authority to sell Secretariat. Priscilla would be bound on the contract, even though she told Andy, don't sell that horse, because she cloaked him with apparent authority to sell all the horses. If she wanted the third party to know that they could not buy Secretariat, she should have said, these are my horses for sale, and not included that on the list. She should have said everything but Secretariat. It wasn't enough. She didn't control her agent, and it is her obligation to control her agent when she has cloaked him with actual authority in the case, with apparent authority. She has cloaked him with apparent authority in the case of this transaction. We're getting short on time. I think we'll do one more. Yes, question.
So if you don't control your agent and it looks from the outside like there's authority, what's the consequence there?
The consequence is the principal will be bound. Any authority will bind the principal. They won't be able to get out of the transaction if there is any authority, whether that is actual, apparent, or inherent. If the court finds that there was authority for the transaction, the principal will be bound by it. And so you have an obligation, even in this case, especially in this case, because think about it from a perspective, not maybe of economics or of fairness, but who is in the better position to control Andy? Priscilla is. And so this creates an incentive for principals to control their agents. Someone is going to get holding the bag here. I mean, either she loses a horse she didn't want to sell, sells it for too little, or she could retroactively, essentially, disclaim a transaction because it turned out to work badly for her. I mean, if we're going to allow her to get out of this, someone else now has to return the horse, now has taken an action, and whatever. We could go through a whole set of transactions. Not so good for the other guy. We're going to make Priscilla responsible for the action of her agent, whether that is by her express or her implied actions, or whether by how she cloaks him with authority for ordinary transactions. And so we'll find, in general, there is an obligation of the principal to control the agent, and this agency law provides that. All right, let's take a look at one more example. Priscilla gives Andrew the same instruction, says don't sell Secretariat. And she sends letters saying, same thing, I'm selling my horses, if you're interested, see Andy. Andrew sells Secretariat now to someone who knows Priscilla, and actually knows that Priscilla would never sell her favorite horse. Now, you're that person. You received the letter. Priscilla said, I'm selling all my horses. Andy's my agent. You know Priscilla. You know she loves Secretariat. You know she spent $10,000 on Secretariat. You know she wants to keep Secretariat. You buy Secretariat. Did you have a reasonable belief that Andy was authorized to sell Secretariat under these facts?
Isn't actual knowledge going to bar you from being able to?
Correct. Here, that actual knowledge, you have actual knowledge that Andy was not authorized. And so you can't hide behind that, right? You're not going, so here, because the theory of apparent authority is developed to protect the reasonable expectations of outsiders and third parties. Here, that third party does not have a reasonable basis for having that expectation. And so, in this case, this is a clear case. The outsider actually knows the officer to the transaction had no authority, and so the transaction will not be binding on the principal. All right, so we'll come back next week and we'll talk about inherent authority and the undisclosed principal and keep kind of working through some hypotheticals here. And then early into next class, we'll also talk about authority of corporate officers. And so please, for next class, read Lee versus Jenkins Brothers. And let me see how, and Menard Inc., the Dage MTI. And let's see if there's anything else I'll need you to do for next class. It's all Menard. Menard's a little bit on the longer side. I'm going to get into ascertaining corporate authority. If you read those two cases, and also, again, look at the bylaws and look at the organizational resolutions, because we'll talk about how those can evidence authority, and we'll begin getting into that next week as well. So please read the two cases, and I will see you in a week.